Good afternoon. Welcome, everyone. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Ward & Smith, and thank you so much for joining us today for our 2021 Fall Employment Law Update. If you have any issues with video or sound quality during this afternoon's webinar, please reach out via the Zoom chat feature, and I'll be happy to troubleshoot with you. We do have scheduled time at the end of the program to answer any questions you may have live. If you have a question at any time during today's webinar, please type it into the Q&A box, and we'll do our best to address as many questions as possible during the Q&A discussion. Now I'll introduce Ken Gray, leader of our firm's labor and employment practice, to kick things off. Ken, the floor is yours.
Thank you, Jen. Good afternoon, everyone. As I sit here in our Raleigh conference room and contemplate what we originally had planned for this fall labor and employment update. Originally, we had planned to be in person at the Grove Park Inn in Asheville, and due to COVID ramping back up, we determined that it would be better to make this a virtual webinar. And while that is, there's a downside to that for the folks out in the Asheville area, it does allow us to reach all across the state, and we do have over 300 people registered and joining us today. So we are grateful that we can reach so many people in this format. As I'm sure most of you know, on September 9th, President Biden announced a six-pronged national strategy to combat COVID-19. And we're going to focus on that particular issue for the first part of the webinar today. And then the second part, you'll hear from the EEOC, and that is, and they will be addressing issues that affect each one of us on this call. And you'll have an opportunity perhaps to ask some questions of our EEOC folks. And then the Ward & Smith lawyers will get back on for the last part of the webinar, and there will be more opportunities for questions and answers. So with that being said, I will give a little bit of a preamble here. When President Biden announced this strategy and provided the outline on September 9th, we believe that we would actually have the rules in hand by probably October 1. Well, here we are more than a month down the road, and we still do not have those emergency temporary standards. So what we're going to do today is give you our assessment of what we believe the ETS is going to say and how it will affect folks. These are educated guesses to some extent, but the real purpose here is to get you thinking about these issues, because what you do not want to do is put your head in the sand and wait until OSHA issues the ETS. You should be planning right now for what you're going to do and have a contingency plan depending on which way issues turn. And we're going to talk about those issues today. And so without further ado, let me introduce our very talented team that's going to be talking. First up, we'll have Devin Williams. Devin is a co-managing director of our firm and is a go-to employee benefits and government contracts lawyer. Now, let me do a quick qualification. All of the attorneys on this call today can talk about any of the topics that we're going to be going over. We pretty much drew topics out of a hat, and so you know everybody's got expertise in these issues, but there are certain areas that each lawyer has that we look to that person as the first line of defense, and with Devin, that's employee benefits and government contracts. Next up, we have Xavier Lightfoot, and Xavier is the North Carolina Society of Human Resource Managers, or SHRM, state DEI chair. And that's quite an unusual position for such a young lawyer, but he has excelled in that area and is recognized across the state as an expert in DEI topics. And he's also one of the top young litigators in our firm. Emily Massey. Emily was a Park Scholar at North Carolina State, editor of the Law Review in law school, and has essentially knocked everything we've thrown her way out of the park since she's been at Warden Smith. And Emily has a very diverse practice. And frankly, if I don't know who else to seek assistance from on a particular matter, I can always count on Emily being that person that can handle the issue. Justin Hill. Justin was a national champion in law school, and he is really following right in Emily's footsteps. He's knocking everything out of the park that is thrown his way, and is developing an expertise in EEOC matters as well as wage and hour issues, and also OSHA issues. Will Oden. Will wears many hats for the firm. In addition to being our primary OSHA expert, he's also president of Warden Smith Business Consulting, which is our consultancy business that's under the Warden Smith umbrella, and Will runs that very efficiently and smoothly, and provides services for folks that need consulting work that don't need to have a lawyer involved necessarily. Grant Osborne. Grant is our NLRA expert, and also our senior most labor and employment attorney with over 30 years of experience. Haley Wells. Haley is probably our most fearless employment litigator, and probably handles the most diverse type of employment lawsuits that any of us are currently dealing with. She litigates cases all across the country, and one of her current cases even has international implications. So I know you'll enjoy hearing from Haley when she talks to the EEOC folks. So without further ado, we'll just turn this over to Devin Williams and enjoy what she has to say.
Thank you, Ken. So I'm going to talk about coverage of what we expect from the impending ETS, the Emergency Temporary Standard from OSHA. There are two main aspects here that we want to focus on. Who's covered in terms of employers that are subject to the rule, as well as employees of those covered employers. To answer these questions, I want you to keep in mind the purpose of the anticipated ETS. That is, vaccinating as many people in the workforce as possible. So let's move to employers. How is 100 or more employees going to be calculated? Is that going to be a pure head count? Each person who's employed as of a specific date, the effective date of the ETS, would they be covered? Or would it take a look back over the prior 12 months? Or as the EEOC has some of their laws that they govern, look at 20 or more work weeks in a calendar year. Or would it be under what we call the full-time equivalent standard? And this is a standard that is utilized by the Affordable Care Act of determining which employers are large enough to be covered by the Affordable Care Act's requirements. While again, as Ken noted, this is all somewhat speculative, it is our educated best guess that, again, keeping in mind the purpose of the ETS to vaccinate as many folks is that the OSHA's ETS is going to try to encompass employers, include as many employers under its regulation by using a pure head count. So how many employees are employed at any given time? It likely will not look back necessarily over a prior year, although it could. More than likely, it's going to look at a combination of as of the effective date going forward, as well as taking a little bit of a backwards look. The idea there is that OSHA, if they're anticipating this, does not want employers to drastically drop their headcount to avoid coverage under the ETS. So they will try to find a way to ensure that employers who either employed that many employees prior to the announcement or are currently employing 100 or more employees would fall under the coverage. Next, you look at which employees are going to qualify as an employee subject to this requirement. Do you think full-time would be covered? Sure. Full-time seems like an easy answer that yes, those folks would be covered. What about part-time? There's plenty of laws within the employment world. You think about employee benefits laws, where part-time employees on some occasions are carved out. Same thing with temporary or short-term employees. They may not be subject to all legal requirements, but here, again, going back to the purpose of the ETS, which is to vaccinate as many individuals as possible, you're likely to see full-time, part-time, temporary, permanent, short-term, however you classify it, that when they step foot onto your workforce, you have an obligation to ensure that they are getting timely vaccinated. And so part-time employees are going to be covered under that. They're also going to count towards your employee count, as well as temporary or short-term employees. Now, what about independent contractors? Well, my question to you, and probably your legal counsel's question to you, would be, are they really independent contractors? Keep in mind the misclassification risk that I'm sure you've heard about, and add this one to the list, that anyone who you have classified either prior to or maybe even riskier after announcement or the ETS coming down, anyone who is classified as an independent contractor, give closer scrutiny to that, because there is a chance that OSHA would take the position, the Department of Labor, which is where OSHA falls under, Department of Labor is going to take the position potentially that that is a misclassification, that was done potentially willfully to avoid compliance with the ETS, and that would come with pretty severe penalties and potential rights that the independent contractor, who's really your employee, could have. Now, more than likely, someone who is truly an independent contractor and meets all of the tests to qualify as an independent contractor would likely not be covered because they are not, quote, your employee. But again, that carries risk, and that analysis is as important as ever on whether it's a potential misclassification issue. Most laws under the Department of Labor define employee very broadly to mean essentially any individual employed by an employer. I don't know about you, but when I was in grade school, I remember learning, don't use the word in the definition to describe the word, but that is how many of these regulations are used. And so that is intended to be broad, it's intended to protect employees and encompass as many people who have that relationship of employer to employee. Now, if you have that relation, that type of definition, which we anticipate something along those lines, something broad to cover as many employees as possible, then think about the other tricky issues we might encounter. Joint employers. This is where you may contract with a staffing company, for example, to staff workers to your work site. You may say, well, those aren't our employees, so we don't have to worry about it. Well, not so fast, because it is possible that those individuals are going to meet the definition of employee under the ETS. And you would have an obligation to ensure, as the plan is written, that those employees are either fully vaccinated or submitting to weekly testing and providing a negative test. So keep in mind that is another obligation that you would want to take into account between you and the staffing company, and realizing that as much as you want to try to avoid that joint employer relationship, you likely have that. So you have that same obligation to ensure those employees are complying with the ETS so that you as the employer can comply with the ETS. The other issue is aggregation of employees for purposes of common ownership, common control, and various other things. You might recall this with the Affordable Care Act, where groups, employer groups, where there's multiple employers, but really it's all the same employer, or it's multiple entities and all the same employer. We anticipate, while probably not the same language that the Affordable Care Act uses, but we do anticipate that OSHA will try to encompass all of those entities that are either in common ownership or control. So essentially they are operated as one employer. Or even if the entities are separate, there's such a relationship between the entities that they do operate as one employer. And that could be a situation where each individual, either employer entity, has its own work site and there's 50 people there and 20 at another site and 50 at another site. You would add up all of those people to then become a covered employer and have all of those employees be covered employees. We, again, going back to the purpose of this as we see it from OSHA, that they will try to implement a regulation that is as broad as possible to cover as many employers as possible and as many employees as possible. With that, I'm going to pass it on to my wonderful law partner, Xavier, and he is going to give us a little insight into federal contractors and the compliance issues there. Thank you.
Thank you, Devin, for the warm introduction, and good afternoon, everyone. Thank you all for being with us today. Today, I'm going to spend some time covering the requirements that were issued by the current administration for federal contractors with regard to mandatory vaccinations, and also address key guidance regarding those requirements. So last month, President Biden issued Executive Order 14042, and that requires various federal contractor employees to get vaccinated against COVID-19. In addition to the vaccination requirement, the order also requires executive departments and agencies, as well as some independent establishments that are subject to the Federal Property and Administrative Services Act, to include what's called clause into covered contracts and contract-like instruments that the contractor and any lower tier subcontractors are required to incorporate into those lower tier subcontracts. Now, this clause requirement, it must specify that the contractor or the subcontractor, they are going to comply with all the guidance that is issued from the Safer Federal Workforce Task Force. And I'll refer to them as simply as a task force for our presentation today. They're going to be required to comply with that guidance for the duration of the contract. Presently, I can tell you that the Federal Acquisition Regulations Council, they have already published their COVID clause and have asked different contracting agencies to develop what they're calling deviations to allow the clause to go ahead and be used in those contracts. The three largest contracting agencies, the Department of Defense, DoD, General Services Administration, GSA, and Veteran Affairs, VA, they have also all published deviations directing their contracting officers to include the council's COVID clause. So but I should tell you that the current COVID clause from the council, it is temporary, and it will be updated when the council adopts a final rule through the formal rulemaking process. So certainly keep that in mind as we navigate through this landscape. Jen, you can advance and start next slide. Thank you. So next, what I want to do is talk about some of the key provisions that came out of the task force's guidance. So following the executive order from the president, the task force, which was led by the White House's COVID-19 response team, issued this guidance to implement the requirements of the president's order. The key provisions, there's three real key provisions from that guidance, with the exception of the COVID clause that I just mentioned. First, that is that, and we've talked about this, that the federal contractor employees working on covered contracts or any employees who perform duties in connection with those covered contracts, and we'll talk about that a little bit more in detail here shortly, And also employees who work at the same workplace as employees who are covered by those contracts are all required to be fully vaccinated by December 8th, 2021. So that encompasses a lot of different individuals who are employed by federal contractors. And, those folks will be required to obtain the vaccine unless the individual is entitled to an accommodation. They may be entitled to an accommodation either due to a disability, which may include a medical condition, or a sincerely held religious belief, practice, or observance. The second key provision from the guidance requires contractors and their employees to comply with masking and physical distancing requirements while in a covered contractor workplace. And finally, the third provision requires covered contractors to designate and train a person or group of individuals within the contractor's organization to coordinate the implementation of the safety protocols which are set out in the guidance. Now, the guidance that was issued by the task force came along with various frequently asked questions and responses to those, just to kind of address some of the current issues that a lot of contractors are dealing with in trying to understand the requirements by the president's order. And what I want to discuss first is, some of the key points to that guidance. I won't cover it all, but I will discuss the highlights and the main points that I believe are most pressing. And so the first thing is, we fielded various questions from our employer contractors concerning, what contracts and employees are covered by the order and the task force's guidance. So what the guidance does, it adopts the Department of Labor's proposed rule on increasing the minimum wage for federal contractors for what will constitute a contract, and identifies various types of arrangements that would be considered contracts or contract-like instruments. That includes procurement actions, lease agreements, cooperative agreements, provider agreements, intergovernmental service agreements, and other types of agreements. The guidance also confirmed that the president's order is intended to apply to contracts and contract-like instruments that are covered by the Service Contract Act, the Davis-Bacon Act, concessions contracts that are not subject to the Service Contract Act, and contracts in which there is a connection with federal property or land related to offering services for federal employees, their dependents, or the public. I can tell you on the flip side of that, what the rule and the guidance does not apply to are those federal contracts that fall below what is called the Simplified acquisition threshold, and that is $250,000, as well as those prime and subcontracts for manufacturing of products or supplies. Those type of contracts are not covered or addressed by the president's order or the task force's guidance. Furthermore, federal grants, the other contracts that are not covered by this particular rule and the guidance are federal grants, agreements with Indian tribes, and contracts where performance is going to occur outside the United States. So certainly keep that in mind. Another question that we fielded is, we know what kind of contracts may be included, but what employees does this rule extend to, and what employees are covered by the mandate? Well, the guidance defines a covered contractor employee as all full-time or part-time employees of a covered contractor who works on a covered contract or in connection with a covered contract. And I'm going to talk to you a little bit more in just a moment about that language, in connection with a covered contract at a covered contractor workplace. So what that includes generally is those employees who perform specific duties on the actual covered federal contract, but also employees who perform duties necessary to the performance of the covered contract. So what I mean by that is the guidance specifies that it can also include employees who are a part of the human resources department or a part of your billing department and your legal department. Even if you have employees who are not themselves working on or in connection with a covered contract, meaning, they're not working at a workplace site where you have a federal contract, and they're not working in connection with the contract. But if they are at a location where they may come into contact with another employee who is covered by the guidance and by the rule, then you have to have all of those employees. All of those employees are going to be required to obtain that COVID vaccine. So if there's going to be any interaction with, employees who have nothing to do with a federal contract workplace or nothing to do with your covered contract employees, but they may run into those employees either in the stairwells or elevators or in your cafeteria, then all of those folks are covered by the rule and by the guidance. Now, I briefly mentioned that employees are required to obtain those vaccines no later than December 8th. But they also are required to obtain it by the first day of performance of a covered contract, option exercise, or renewed contract, whenever the clause is implemented and incorporated into those contracts. So what that timing looks like is that, in new federal contracts or contract-like instruments that are awarded on or after November 14th, 2021, that's when that's going to take place. And when you will want to have, compliance with the guidance according to those contracts that are going to come down with the clauses by that date. If you have existing contracts that, you have an option that can be exercised or an extension is issued, then you want to look at the timing requirements for when the clause is going to be set to take effect for those contracts. In any new solicitations that are issued on or after this October 15th date, the contracts that are awarded pursuant to those solicitations, then you will want to make sure that you are in compliance by that date, that October 15th date. So there's a lot of nuances and there's some differences in the timing requirements. The main thing is that you want to make sure that your subcontract agreements, that any agreements you have with subcontractors, you come into compliance with those clauses by the dates that I just mentioned, either the October 15th or the November 14th deadline, depending on which type of contract you have. Lastly, the guidance addresses a very important question, which is, what is a prime contractor's responsibility for verifying that subcontractors are adhering to the mandate? And so the prime contractor, the general contractor, is responsible for ensuring that the required COVID clause is incorporated into its first tier subcontracts. Once that is incorporated, then that requires all other lower tier subcontractors to flow that requirement down to those contracts. So that is the prime contractor's responsibility. Lastly, what I would like to leave you with is, what action should you be taking at this point in time to prepare? The first thing you want to do is review your existing contracts and think about any anticipated new government contracts that you may receive, and figure out, what's going to be the timing requirement for when you need to comply with the rule. The next thing that you want to do is to designate a compliance person or a group of individuals within your organization who are going to be responsible for coordinating the plan to get your employees to stay in compliance with the guidance. that person or those individuals will also should also be responsible for obtaining the proper documentation that you are going to need to be able to determine, if your employees are in compliance with the vaccination mandate or not. So that's going to be a part of this process. Is you're going to have to get that information from your employees to determine that they have in fact received a COVID-19 vaccine. Next, determine which employees and or work sites are covered by this rule. So it may not be the case that all of your employees are covered, but as I mentioned, this is intended to apply very broadly, right? And you may have a situation where you've got employees who are going to be employees who are not interacting with, it may be a situation where you have employees who are not on a covered contract, but they're interacting with those covered contract employees. And in that case, they will need to comply as well. And then you want to continue to monitor the task force guidance because it will get updated. There will be new developments to come. So keep that in mind as well. Now I'm going to turn it over to our fearless leader, my good friend and mentor, Ken Gray, to discuss our next topic. Thank you.
Thank you, Xavier. And just before I get into this, I will say we've already gotten about 5 questions in the Q&A and chat. Keep the questions coming in the Q&A. We will get to those at the end in the Q&A in our question and answer session. However, if we get too many, we'll start answering them electronically to the person that sent them, just so we don't run too far over this afternoon. So the topic I'm going to talk about is related to healthcare. And one of those 6 prongs in President Biden's outline on September 9th was that workers, and I'm quoting language here, in most healthcare settings will be required to be vaccinated. Okay, well, if it says most healthcare settings, then that means there are some that are not going to be covered. And so we're just going to have to wait and see. Now, unlike what you've heard Xavier and Devin talk about, where we're waiting for OSHA, in regard to Xavier, OSHA's already issued an ETS. And in regard to what Devin talked about, we're expecting an ETS from OSHA. Actually, what we're going to see in regard to the healthcare industry are standards coming from CMS, the Centers for Medicare and Medicaid Services. And so it's going to affect most healthcare providers that receive Medicare or Medicaid, and that is most of them. And so we'll have to wait and see what is going to happen there. Certainly, even when you require a vaccine, as Xavier said, you still have the potential obligation to consider medical and religious accommodations. Now, prior to President Biden speaking, OSHA had already spoken earlier this summer on June 21st regarding the healthcare industry, and it issued a set of emergency temporary standards that basically declared SARS-CoV-2, which is the virus that causes COVID-19, a grave danger to workers in healthcare settings where people with COVID-19 are reasonably expected to be present, and thus it issued that ETS. The ETS that it issued applies to settings where any employee provides healthcare services or healthcare support services. And healthcare support services would be billing, reception, working in the patient files. So even though you don't have direct patient contact, you still can be subject to this ETS. It includes employees in hospitals, nursing homes, assisted living facilities, emergency responders, home health care workers, and employees in ambulatory care facilities. Ambulatory care for folks outside of the medical field, that's your doctor's offices. It basically applies to anybody unless they are just applying first aid and are not a licensed healthcare provider. It doesn't apply to dispensing of prescriptions by pharmacists in retail settings. It does not apply to non-ambulatory care settings where all non-employees are screened prior to entry and people with suspected or confirmed COVID-19 are not permitted. In other words, if you don't allow anyone that may have COVID-19 to come in the building, then you're not subject to that. And then also, if it's a hospital ambulatory care setting, if you do the same thing by not allowing folks that may have COVID-19 to come in and all of your employees are vaccinated, then you're not subject to this ETS, but it's very rare that everybody at this moment would be vaccinated at a hospital. It does not apply in home health care settings where all employees are fully vaccinated and all non-employees are screened, and folks that are potentially COVID positive are not allowed to come in. It also does not apply to health support services that are off-site. So if you do laundry or off-site medical billing and you're away from the main doctor's office, you're in a completely separate administrative building, then you are exempted from the ETS, and it also does not apply to telehealth services. But unless it was one of those things that I just mentioned as an exception, then it does apply. And basically what the ETS requires is that everybody that's subject to the ETS must have a COVID-19 plan. It's detailed as to what must be in that plan. And as Grant will tell you later on, I think we're going to see a very similar obligation under the ETS that comes out of OSHA for everybody else outside of healthcare as well. It addresses patient screening and management issues. It addresses personal protective equipment, health screening and medical management, vaccination, training, record keeping. It has a very detailed list. So if you're a medical provider and you're not familiar with this ETS, then I would suggest you become very familiar with it. And I can give you a website, www.osha.gov/coronavirus/ETS. That will give you the entire list of regulations and the frequently asked questions, and you can get most of your information from that. And Jen has just put that up. The most remarkable piece of this is that if you have someone that's exposed in the workplace and gets COVID, then you cannot terminate them, and you have to, depending on the size of the employer, if you're between 10 and 500 employees, you got to pay them their up to $1,400 a week. Beginning in the third week is capped at $1,000. For employers over 500, it's $1,400 per week, capped at $1,400 per week, and it could potentially go on indefinitely until the person is essentially cleared to come back to work. And if someone was hospitalized as a result of COVID, then again, it can go on for months. And the ETS does state that you cannot terminate them unless it becomes very clear. They acknowledge they're not coming back to work, or it's crystal clear that they're not coming back to work. But otherwise, you're obligated to keep them on the payroll at the same benefit level as they were prior to going out with COVID. So with that, I will turn it over to Emily Massey.
Thanks, Ken. I'm going to briefly talk about testing, meaning that I'm talking about the part of President Biden's plan that applies to employers with 100 or more employees. So what Devin talked about earlier. So this does not apply to federal contractors who are required to implement mandatory vaccination. This is for employers who choose to take the option, either to require vaccination or allow for weekly testing. So in short, what President Biden's plan says is that employees who are not fully vaccinated must produce weekly negative test results. Now that creates probably more questions than answers. So we expect many of those answers to be provided in the ETS, but here is what we are hypothesizing will happen. So first of all, what type of test will be acceptable? A PCR, a rapid, a home test? We expect that the ETS will specify exactly what type of tests are acceptable. And we've seen that, for example, the CDC has an order for international travel, and it indicates that rapid tests and home tests are acceptable so long as they are antigen tests or nucleic acid amplification tests. So we expect something similar from the ETS to give us some specification as to what type of test will be acceptable for those weekly negative results. Now, while President Biden's plan promotes making at-home tests more affordable, the types that you've seen at Walgreens and other types of retailers, we expect that the ETS will either not allow for home tests or will have stringent requirements for authenticating the identity of the test taker. For example, think of a drug test and not being allowed to bring your own urine specimen from home. Kind of the same issues we expect the ETS to address with home tests. And the CDC has addressed this type of issue too in its international travel order, saying that if you take a home test, that's acceptable only if you have a telehealth conference with a healthcare provider who confirms your identity and that you're the one actually taking the test. The next question that this raises is, will the employer be required to pay for the test itself? The short answer we expect is yes. Generally speaking, when an employer requires a medical related test, i.e. think of a drug test, it must pay the cost. There are also many state specific laws that require payment of these types of medical expenses that are related to work. So we do expect that this information will be very clear in the ETS. The Department of Labor has said we expect there to be a clear designation of who bears the responsibility for COVID-19 testing. But our guess is that, yes, the employer will be required to pay the cost of the actual test. Another question is, will the employer be required to pay the unvaccinated employee wages for time spent getting the test? Again, generally, we think the answer is yes. This issue, however, will not typically impact exempt employees who, as you know, must be paid their same salary if they work at all during any work week. But for non-exempt employees, the standard rule under the Federal Fair Labor Standards Act is that the employer must pay non-exempt employees for time spent undergoing medical testing during the workday. Now, what about getting tested outside of work hours? This ETS is going to require weekly testing, and depending on the type of test that's required, it could take multiple days to come back. And if you're expected to show up for work on Monday, that might mean that you get the test on Saturday. Will the non-exempt employee need to be paid for time spent getting the test on a day off, for example? Our thinking is that yes, most likely a non-exempt employee must be paid for this time. The Department of Labor previously released guidance about COVID-19 testing required by an employer on a vacation day, and essentially said if getting the test and having a negative test is necessary for the employee to perform his or her job safely, and the employer requires the test on the day off before the employee can return to work, then such time getting the test on the employee's day off is compensable. This concept will likely translate to the ETS as getting the weekly test will be required for unvaccinated employees in order to return to work and under this new standard. So there may be ways to avoid this issue, which, as Grant will talk about later in formulating your plans as to how to implement these requirements. It could be that you can require that the test be taken during work hours, and that will help avoid those types of issues. But this is our general estimation of how these wage and hour issues are going to play out. In general, as Devin said before, we expect the ETS to place significant requirements on employers including to meet this weekly testing standard, because the whole objective behind this plan and the ETS is to encourage mandatory vaccination. So we think that in essence, the ETS will discourage or place some burden on employers who choose to give employees the option either to do weekly testing or mandatory vaccination. With that summary, I am pleased to turn it over to Justin Hill to talk to you about wage and hour issues related to vaccinations themselves.
Thank you, Emily. So on the other side of what Emily just talked about is employees actually being vaccinated. So as she just said, the two options are that employees will undergo weekly testing or they will become fully vaccinated. So the first thing that I want to start off with is what the potential deadline for employees that choose to be fully vaccinated will look like. So there's a very likely chance that we could see multiple deadlines, or at the very least, we will see a deadline, and then we'll also see a timeline for how employers need to act to be in accordance with that deadline. The emergency temporary standards for healthcare workers had multiple deadlines. You saw 14 days to satisfy some of the requirements, such as getting the plan in order and such, and then you saw 30 days for them to meet the other requirements. However, with the federal contractors and what we think is more likely to happen with the employers with 100 or more employees is that there will be a timeline that gives about 2 to 3 months for employees to become fully vaccinated. And at that point, that will be the cutoff. So at that 3-month mark or whatever that date may be, all employees that are covered under it and do not have accommodations will likely need to be vaccinated, and that will kind of be the end of it. But on the other side of that, of course, there are emergency situations that arise. What we've seen in other situations, such as the federal contractors rule, is that with emergency situations, there are, grace periods given. So something along the lines of 30 or 60 days for the employee, depending on the situation, to become fully vaccinated, or an extension of time is something that is very likely to be put in and spelled out in this emergency temporary standard whenever it finally does come out for us. So the other part of that is, what can employers do to ensure that they meet that timeline? That's where the planning comes in that Grant will talk about. That's where the encouragement comes in. That's where making sure that whatever decision it is that employers make, whether it be providing the testing that Emily just mentioned, or it be making sure that your staff is fully vaccinated as a whole, they need to kind of make sure that they're up on that. They don't put their head in the sand, and that they're preparing to do whatever it is that they want to see happen, and they need to do it early. Because if you wait until you're so close to that deadline, you're gonna run out of time. You have to have the time for people to receive the doses. There's about a 28-day period in between the first dose and the second dose. And then, you still have that waiting period as well. So with that being said, I think the smartest thing to do for employers is to go ahead and jump ahead and be prepared for what's going to come. So what does fully vaccinated look like for employees? As of right now, the best guess for what fully vaccinated means is simply the 14 days after you've completed 2 doses of the Pfizer or the Moderna vaccine, or 14 days after you've completed the only dose of the Johnson & Johnson vaccine. However, this is something that we could see changing as well, and it could change before the emergency temporary standard is actually released, depending on the timeline for that release. With the rise of the booster shots coming up, and as they continue to become more and more popular, more readily available, and they get full approval by the FDA, we can expect that booster shots will also be something that may be required by the emergency temporary standards. And when that timing will come, we can also expect that these standards will have something that allows for amendments so that they can make such changes and just kind of implement it into the standard without having to go through the full process of another release of an order. The next topic to look at is how use of paid time off, or PTO, will play out here. One of the main goals that President Biden put in his executive order is, and I'm quoting here, to ensure that no worker loses $1 of pay because they got vaccinated. So as many of my colleagues have mentioned already, the key goal is to get as many people vaccinated as possible, but the deterrent of having to pay for it themselves is obviously something that the president wants to try to avoid. And it's something that he's going to place on employers. Now, the question becomes, how does that play out? What are the requirements for employers? And here are the questions that we've got here. So what must an employer do if an employee does not have available or unused paid time off? We think the short, simple answer here is that employers will be required to offer that paid time off, whether it be accrued leave that they allow their employees to use already and they've run out of it, or whether it be a separate bank of leave that they've created solely for COVID-19 vaccinations. We do believe that what's going to come here is that employers are going to have to offer that time for employees to go out, to be vaccinated, and to also, have the recovery time following. The next question we had was, may an employer impose limits on how much time is offered? So what we've seen lately in different states and in different sorts of guidance that come out is that the guidance itself places limits on it and the employers don't have to do so. So there are some states that generally limit the time off to 2 hours per vaccination shot. And New York also allows 4 hours per vaccination shot. So that kind of is a limit that's imposed through the regulation itself. So employers don't have to be the bad guy and set a limit. However, what we saw in the healthcare field that Ken mentioned earlier was that they allowed a reasonable time off, but what they did was they told us what would be considered to be reasonable. So with that being the case, they said that if you offer 4 hours off for each dose, that limit is already deemed reasonable. There's no need for you to, be concerned if that's the limit that you place on your employees. I think the important thing to remember for employers who do not place these limits, though, is reasonable time off is going to include a lot. So for example, it's going to be time spent during work hours to make the appointments. It's going to be registration time, filling out paperwork, the time spent traveling. It's not just the time that someone's actually in the chair receiving the injection for the vaccine. So it's important that if you don't place limits on you, you make sure that you're keeping up with the time that is taken. On the other side, I think that we also need to remember that even if someone is getting the shot in a time that is not, their normal working hours, the time that that person needs to recover is still going to be time that's covered. It's still going to be time that employers need to work in and make sure that they're offering time off for it. And it's still going to be time that needs to be paid. The next question is, how may an employer lawfully respond to an employee who has exceeded their permitted time off for vaccination or for post-vaccination illness? So it seems like the simple answer here is going to be that time is time that they don't have to pay for. But again, it comes into what sorts of limits we look at. What we've seen in other emergency temporary standards for post-vaccination illness is that they've offered 16 additional hours to the hours that it takes for someone to get vaccinated. So basically 8 hours after each shot or one standard workday is what they've allowed and said that would be deemed as reasonable. But as Ken mentioned earlier, you also have seen financial pieces, so limits of $1,400 per week. And those sorts of things could run long. They could go, until that person, if he's hospitalized, until that person gets better. So these are the sorts of issues that we could see here, and making sure that those limits are spelled out is something that we expect from the emergency temporary standard. And we hope that they give us true answers that allow us to craft policies that make sense. So following that, where can the employers go to look for guidance? There are state laws out that already allow for time off for vaccinations, excuse me, whether it be California, Illinois, Massachusetts, Nevada, or New York. They all have statutes that either allow time specifically for COVID vaccinations or they allow their sick leave statutes to be used for that time. So it's important to kind of look at what's happened there and try to craft policies prospectively to settle what you think could come. That way, it's not, someone rushing as soon as these rules come down. Additionally, you can look at the federal contractor rules and subcontractor rules that Xavier spoke about, or you can look at the rules that have come out for the healthcare or other industries that have specific rules stated. And with that, I'll go ahead and pass it to my good partner and friend, Will Oden.
Actually, Will just texted me and said his screen is frozen and he cannot unmute. So Grant, can you go next?
Yes, I'll be happy to. And I guess after I've made my presentation, I'll offer the podium back to Will. Good afternoon. I thought I was batting cleanup. Maybe I am. My subject with you today, I wish I could see all of you, is what kinds of policies, if any, should employers have with respect to the expected emergency temporary standards? Actually, I have the luxury, since we haven't seen these standards, of being able to say that of what I'm about to say to you is almost certainly not wrong or irrelevant. We don't know what these standards are yet, but I believe that the issues that I'll address in a moment should almost certainly be addressed in personnel policies. Good personnel policies are like insurance policies. They're a luxury until you need them. Many of you may already know that there are actually very few personnel policies that are required by law, but there are many that are highly recommended. When it comes to a subject as frankly novel and thorny as this, we fully expect that prudent employers will have policies, personnel policies, addressing many of the issues that we believe these new standards will implicate. Obviously, we don't know exactly what they are. My colleagues have addressed what many of them are expected to be, and we're confident that we're almost certainly accurate as to what those issues are going to be. But of course, we simply don't know yet. Having said that, let me identify a few, which I think you see on your screen. A few of the kinds of issues that we believe employers will almost certainly encounter as a result of these new standards. And again, I cannot emphasize enough in the short time that we have to say that policies are really, really wise. You need to have a written plan of some kind, because a goal without a plan is just a wish. And when it comes to managing legal risks, mere wishes are not the way to go. So with that preface, let me just look at a few of the kinds of issues that are before you now that we think all employers covered by these standards will almost certainly encounter. And I feel like I'm beginning each one of these with the phrase, what if? That may sound hypothetical and perhaps not very helpful, but we think it will be once the standards have come out. So number one, what if an employee refuses the vaccine, then tests positive for COVID-19 and is symptomatic? What are you going to do? We think that rather than shoot from the hip, a good policy will address that highly, highly likely situation. What if an employee refuses the vaccine, tests positive, and is asymptomatic? Does that suggest a different course of action? A good policy would address that as well. What if, and again, I apologize for the repetition, what if the employee refuses the vaccine, tests positive, and is symptomatic, but says, wait a minute, I am willing and able to perform the essential functions of my job remotely, away from coworkers, patients, customers, vendors, etc. Will you permit that? Must you permit that? A good policy will at least try to address that highly probable circumstance. Better yet, perhaps even thornier, what if an employee refuses the vaccine, tests positive, and is symptomatic, and is able to perform the essential functions of his or her job remotely, but the employee refuses to do so? A good policy will address that circumstance as well. At a more general level, a higher level, what about the security of your confidential information in the case of remote work generally? If you don't already have a policy that deals with that issue, then we would recommend that you do, because these days, as we all know, many employees have begun to work remotely, and that raises all kinds of issues regarding security of proprietary information, trade secrets, and confidential information of various kinds. Finally, the last two, and again, these are just selected by us from frankly, a list that could involve dozens of issues. But we hope these get the wheels turning and indicate the prudence, the wisdom of having policies that will address the issues that will almost certainly be implicated by the new standards. What if an employee gets the vaccine, says, fine, I'm happy to get it, gets the vaccine, and then claims to become ill and disabled as a result? What will you do then? Should you have a policy that addresses that scenario? We think the answer is clearly yes. And finally, what if an employee gets a vaccine and then claims as a result of the vaccine to be suffering from a serious health condition? The last issue I mentioned, of course, implicates the Americans with Disabilities Act. This final issue, that is the case when an employee says, I've gotten the vaccine, I thought I was good, but now I've contracted a serious health condition. If not by those words, gives you enough information to make it clear that the employee has or may have a serious health condition allegedly tied to the vaccine. Might that happen? Well, certainly it may. And in fact, large employers will almost certainly encounter that. And a wise employer will have a policy that addresses, or at least provides some indication of what the employer's policy is going to be in such a circumstance. Again, we don't know what these standards are yet. We expect to see them soon. There'll be a lot of issues that will come up. We think we've addressed most of them, but we believe some will come up that we haven't seen yet. But the bottom line is you will want a personnel policy that addresses the issues implicated by these new standards. We're all moving at a very rapid pace these days. This represents a new paradigm for, frankly, all employers covered by the standards, because the standards will impose burdens on employers to which they are very unaccustomed, and frankly, to which employees are very unaccustomed. So we think that you can avoid a lot of misunderstandings and frankly, many disputes with a good personnel policy that addresses these issues. I believe that my good friend and partner, Will Oden, is back. So with that, I'm going to see whether I can lateral the ball to Will Oden. Will?
I am back, and I apologize for that technical difficulty. As I was rebooting my computer, it did give me an opportunity to think, these issues are not easy. And we recognize the grace with which all of you on this video conference have handled the unknowns and the pivots. And we don't want you to feel alone in all of this, so please do feel to reach out to us. Also, very quickly, I would commend to you an article that Haley and I wrote that has just been published in Business North Carolina magazine on mandatory vaccinations. And then finally, I would just say that regular OSHA complaints are still out there. And the best thing you can do is pick up the phone and let them know you've gotten it and submit a written response early. That typically resolves the issue. So with that being said, we only have a few more minutes. Talk real briefly with you about proof of vaccination. What counts insofar as proof of vaccination is concerned? A written attestation is not enough, obviously. A copy of the vaccination card is sufficient, and it's perfectly fine to request this for those of you who are requiring vaccinations and for those of you who will later be subjected to President Biden's plan, which will be enacted by the ETS. It's fine to collect this information via email. Who handles collecting proof of vaccine really needs to be a limited number of individuals on a need-to-know basis. Human resources preferably. Where do you keep what you receive is very important. Cannot be kept in the general personnel file of the individual. Much like any medical information, should be kept in a separate file because the EEO's position, rightfully so, is that medical information should not form the basis for an employment decision, and for that reason should be kept separately. And that's going to help you to avoid any HIPAA or privacy breach issues. We've had some clients raise the issue of what about wristbands or badges, requiring employees to project their vaccination status that way. That is not advisable. Certainly raises certain privacy concerns, and just from a practical perspective, certainly has every potential to worsen employee tensions on this often divisive subject. The last thing I'll mention is that what do we do if an employee falsifies proof of a vaccine or a test? Of course, and those of you I work with on a day-to-day basis know that I'm going to say it all depends on the factual circumstances, but typically what is appropriate, you know, can be disciplinary action up to including termination depending on the circumstances. And of course, you need to consult your legal counsel. And then finally, I'll just say similar circumstances should result in similar discipline. Otherwise, you risk potential Title VII discrimination issues if those that are more harshly treated are within a protected category. And then actually, I'll add one other point, which is, you know, what is our duty to ensure that the offered proof by the employee is genuine rather than counterfeit? I would just, from a practical perspective, say, I don't think that we're required to be bouncers sniffing out fake IDs. If it appears to be legitimate and we have no reason to believe it's false, it's reasonable to rely on the record that the employee is offering up as proof. Obviously, you can speak to your counsel if you have any questions about a specific circumstance. And that's it for me. And then I will just announce that we are now going to have a break, and we will be back at 1:10. And thank you so much.
Welcome back. I am thrilled to introduce two of the EEOC's finest. We have Tom Colclough. He is a dynamic and repeat presenter for our labor and employment conferences and seminars, and we're thrilled to have him back again with us this year. Tom currently serves as the District Director for the Equal Employment Opportunity Commission, the EEOC. Tom has over 25 years of experience with the EEOC, including investigating charges and complaints of discrimination and leading high-performing teams. He has served in various leadership positions at the EEOC, including enforcement supervisor, local director, area director, systemic coordinator, and deputy district director. In his current position, he plays a key role in fulfilling the agency's mission through strategic enforcement management and planning. Please help me welcome Tom. In addition, we have Glory Gervasio, who is newly the director of the Raleigh area office for the EEOC, appointed in 2020. Prior to her selection to the position in 2020, Ms. Gervasio served as the director for EEOC's Honolulu local office and began her career with the commission as an enforcement investigator in 2001. She continually provides outreach and educational assistance to various committees in her jurisdiction. We are excited to welcome Glory to our presentation from the EEOC. We also have Haley Wells, our very own, serving as the moderator for Tom and Glory on a discussion regarding the EEOC and what is going on in the world these days between the pandemic and various other initiatives of the EEOC at this time. I will hand it to Haley so that she can help lead us through this exciting conversation with Glory and Tom. Thank you.
Thank you, Devin. And a special thanks to Glory and Tom for joining us today. Glory and Tom, to get us started, I think oftentimes it's easy for us to lose sight of the amount of work that you guys are having to complete with the limited resources that you have and the limited staff that you have. And so I thought it would be helpful for our panelists if you can just start us off by kind of walking us through how many EEOC charges you guys see in a typical year. And of that total number of charges, how many of those charges then move through the various processes, whether that be being referred to mediation, to conciliation, and or to litigation. Oh, Tom, I think you're muted. There we go.
You are correct. I was having a conversation all by myself. Well, good morning, Haley, and absolutely exciting and thankful to be back with you all again this year. At EEOC, we normally receive around between 65 and sometimes 100,000 charges per year. This year, we were more around the 65,000. What does that translate to in our district? Our district received about 5,500 charges this year. Of that 5,500, 17.8% of those cases we were actually able to resolve through the negotiated settlement process, or a person withdrew the charge, or successful conciliation. We completed about 500 successful mediations, and in those mediations, the mediators brought, they resolved them for around $10 million this year, just shy of 10 million. The other cases, I would say about 65% of those cases, we issued a no cause violation, and about 29% of those cases, we actually dismissed immediately as soon as they were filed, because we deemed it either they were untimely filed, or we did not feel that with our investigation that we would find that a violation occurred.
Thanks, Tom. Kind of staying on that same topic, let's talk a little bit about the top categories of charges you're seeing and what types of discrimination these charges and these charging parties are alleging occurred.
I'll toss it over to Glory.
Okay, so thanks, Tom, and thank you all. It's a pleasure to be here, and I'm so looking forward to working with each and every one of you if I have not already. Just piggybacking on Tom, I think as far as the Charlotte district, we sort of mirror the national statistics. So nationally in 2020, retaliation is the number one charge that has been filed with our agency, with 55% of all charges received last year include a component of retaliation. Followed by disability at 36% and race at 32%. So again, in North Carolina, that statistic sort of mirrors that. Retaliation is quite high, with 57% of all charges filed with our offices here in North Carolina, including a component of retaliation, followed by disability at 38%, and then race at 35%. Now this is really interesting because last year, actually, the previous year, race was actually the second type of charge that was filed. So I think we're seeing a trend now, I guess, because of COVID and all the reasonable accommodation requests, vaccinations, mandates. We're probably going to see a rise in disability charges in the near future. So that's probably one to look at.
Thank you, Glory. And you essentially answered my question before I could even ask it, and that is whether or not you attribute that switch in race and disability total number of charges to COVID related charges. As we look at that breakdown with retaliation, disability, and race being the top three categories of charges, talk to us a little bit about how that aligns with the agency's enforcement priorities. And that is the types of charges that the EEOC is choosing to prioritize when it comes to either its investigative resources or its enforcement resources.
Well, I think that when we look at our strategic enforcement priorities, what we try to do at the Charlotte District is we try to make sure that our purpose actually matches our work. So at everything that we do, we're continually looking at those strategic enforcement priorities, which again, there are six, as you know. The national priorities: one, eliminating barriers in recruitment and hiring; protecting immigrant, migrant, and other vulnerable workers; addressing emerging and developing issues; enforcing equal pay laws; and preserving access to the legal system; and also preventing harassment through systemic enforcement and targeted outreach. So pretty much what we try to do within the Charlotte District is, as we work with our legal and enforcement teams, everything again that we do, Haley, is centered around those strategic enforcement priorities. The other thing that we look at is we also try to have a district complement plan, and the things that we see within our own district that we feel are important. And for the most part, again, we're looking at those vulnerable workers. Also, emerging issues dealing with ADA. As you know, COVID is an emerging issue that continues to develop every single day. And also making sure, since retaliation is the number one priority, that is something that we take very seriously. Believe it or not, it's not just the number one basis of discrimination in the private sector, but also within the federal sector. So even our federal sector administrative judges, we're all dealing with the exact same issues. And for the most part, trying to work along those same lines.
And Tom and Glory, when we talk about retaliation charges, I typically think about this being someone who has either, objected to some sort of harassment or discrimination that they have experienced in the workplace, or they've gone a step further and perhaps even reported that to the Human Resources Department and then later suffer some sort of adverse employment action as a result of them making that report. Is that the nature of the retaliation charges that you guys are seeing, or are there other instances of retaliation or examples that you can provide to our attendees?
I think I can add to that. Just following up on Tom, I think there's more to it, retaliation, than just the mere opposition or, exercising right to complain. We look at it broadly as far as engaging in a protected activity, correct? So, as I said earlier, disability again is on the rise, and there's a component of retaliation when somebody requests a reasonable accommodation due to their disability. So we see that a lot. An example is if an individual requests leave as a form of reasonable accommodation, right? And they take leave, they return to work, and they find that they don't have any job to return to. So that could be a form of retaliation. So, another aspect of, requesting leave is if there is, if there's a no-fault leave policy or a limited leave, that could potentially be retaliatory because of the mere fact that, they had requested reasonable accommodation, and that in and of itself is, engaging in protective activity, which falls into retaliation. That helps.
Thank you, Glory. That does help. Let's switch gears a little bit and talk about COVID vaccinations. I know that you guys have expressed that you have seen an uptick in some charges related to these two topics. And so I'd like to spend a little bit of time talking about that. At our May 2021 Employment Symposium, we asked if the EEOC was seeing an uptick in charges related to COVID, whether that be mask mandates or vaccination requirements. And at that time, the EEOC reported that, the answer really was not yet, but that it was expected that they might be coming. Since that time, that is from May, until now in October, have you seen a market increase in charges related to COVID, whether that be the disability related charges that you referenced earlier, Glory, or religious discrimination based charges, retaliation? Share with us, if you can, what you guys are seeing, from your perspective.
I think that because we're in fiscal year 2022, and that is actually one of the strategic priorities that I've identified, that I am going to take a guess and read the tea leaves that we're going to see a huge increase in COVID-related charges and inquiries being made to the commission this year, both on ADA issues as well as religion. I think one of the big issues that we're probably seeing all across the nation as you watch the news daily, and that is regarding vaccination mandates. And one of the things that I'd like to just refer folk to, and that is our May 28th, 2021 guidance on our website. We clearly state that, and I quote, that federal laws do not prevent an employer from requiring all employees physically entering the workplace to be vaccinated for COVID-19. And that is subject to the reasonable accommodation provisions of Title VII, the ADA, and other EEO considerations. As you saw in the news yesterday, I think in New York, that the courts clearly told the state of New York that for their teachers and other workers, that you have to entertain the reasonable accommodation process. You just can't say no.
Yeah, I think just piggybacking on Tom and echoing what Tom says, nationally, we are going to be seeing a rise of charges. We're already seeing a lot of inquiries, as you've seen in the news lately with United Airlines, Southwest. Actually, just taking a step back with United Airlines, I don't know if you folks have read, Bloomberg Law, where, there was a court order that basically kind of put a stay on United Airlines vaccination mandate of, having them put those individuals who have disability or religious exemptions on unpaid leave. So that's really interesting. And we are actually still waiting guidance from our headquarters on how to address that. So it is unfolding as we speak. And so, even the EOC is, trying to get, some sort of grasp and trying to get some sort of guidance out to even the field staff on how to proceed on that. So stay tuned.
Gloria, I appreciate you mentioning that case. I was actually reading about it last night and saw that basically the judge ordered that placing employees on unpaid leave is not a reasonable accommodation. So, kind of ordering United to go back to that interactive process that we're all very familiar with and saying, that's not going to cut it. You've got to explore whether or not there are other reasonable accommodations that may be available in light of your vaccine mandate.
Indeed. And I actually just wanted to add to that, as far as statistics locally, I mean, we haven't really seen that many, I guess, COVID charges, but of those that we have seen, they do have that component or where a respondent or the employer is basically saying, well, we provided, an accommodation by placing the individual on unpaid leave. So I think with this recent, court order, that sort of, helps us in terms of analyzing those type of cases. So again, it is, it's unfolding as we speak. And it's definitely exciting to know. Yeah.
Yeah, the other component that I would just mention about that, it's kind of a case we were discussing this morning, and that is for employers to beware not to engage in harassing behavior based on religion or disability due to someone. I think the case we were discussing this morning is that the employer was telling employees, hey, you don't trust God if you're wearing a mask, so you can't wear a mask at work. So that becomes an issue. And what I would say is that if an employer sees a supervisor or someone engaging in that type of behavior, make sure they take immediate and appropriate action to stop it.
Thank you, Tom. Very helpful reminder. I think it would be interesting if we got back together, let's say in 6 months, and had this conversation again, particularly in light of the ETS that OSHA has issued with respect to healthcare workers, and now the anticipated ETS that's going to cover, large employers in the United States, and whether or not the EEOC at a national level is going to issue any more technical guidance with respect to how employers must consider requests from employees that they not have to comply with the vaccination mandate. If employers are going to continue to have to go through that interactive process for all disability and religious related exemption requests. Before we leave this topic, I did want to note that I saw on your website back, I guess in September, that the EEOC had issued a position that it is adopting the Department of Health and Human Services position on long COVID with respect to classifying that as an ADA disability, depending on whether or not it has a substantial impact on daily activities for an affected individual. And so, I think that bears mentioning as we talk about these disability related claims that are, kind of growing out of COVID in the pandemic. That is, employers need to be sensitive to this notion of long COVID, need to educate themselves on what it is, so that if they have an employee who contracts COVID, recovers from it, but continues to have these lingering symptoms, whether they be, ongoing fatigue, brain fog, things of that nature, that they recognize that can qualify as an ADA disability and should engage in that interactive process.
You're correct, actually, Haley. And I just wanted to just echo that as well. Under the ADAAA, right, we sort of brought in the coverage on individuals with disabilities. And one of the things that we sort of point out with regards to that is that, is that any type of disability that is temporary, right, could potentially be substantially limiting. So, you still have to make that analysis, despite the fact that, somebody could have the flu, that in and of itself could be disability if it's substantially limiting in a major life activity right then and there. So you really do have to keep in mind the ADAAA and, the broadened, the impact it has on whether unassessing an individual's disability at that point.
You're absolutely right, Glory. And that's a great reminder that, the analysis of whether or not, a particular individual has a disability is usually a pretty shallow analysis. And the EEOC and the courts have instructed employers that they really need to kind of move on to that next step, and just go ahead and engage in that interactive process and sort of resolve any doubt in favor of finding that there is a disability, and that it substantially limits a major life activity, lest they put themselves in a position where they get to know you guys better through the form of an EEOC charge.
Indeed, Haley. Right.
So let's talk a little bit about reasonable accommodations. It seems that with the pandemic and the impacts that it had on the workplace, it sort of expanded this notion of which positions are appropriate for telework for many employers, because many employers suddenly found themselves in a position where they had to transition the majority of their workforce, if not all of their workforce, to a remote or a virtual environment as opposed to an in-office environment. And so I'm just curious, from the EEOC's perspective, if sort of that ability for a lot of employers to shift to a telework environment or a telework mode has in any way impacted what the EEOC is looking at when it's determining whether or not a requested accommodation is reasonable. And to put a little finer point on that, does the EEOC ever consider, when it's looking at a denied request for a reasonable accommodation, at whether or not the employer allowed other employees in that type of position to telework, or if the employer has generally allowed teleworking for its workforce? Or is it a more individualized assessment where you guys are just focused on what the employer is saying about this particular individual and in this particular position?
Well, I think for me, one of the things that is important to look at, and I'm gonna steal one of Glory's terms, that accommodation does not start with the capital A. There are different ways of looking at the accommodation. For me, the most important thing about accommodation is, does it allow the individual to perform the essential functions of the job? I know that a lot of people think that telework is the first thing that you go to. Well, to me, that telework is just one of the many tools of accommodation that the employer may have in their toolkit. And accommodation, while it may have worked at the height of the pandemic, it may not necessarily be what the employer feels is the right thing for their business. The most important thing, again, is to always go back to, if I, decide to do this accommodation, will it allow the person to perform the essential functions of the job? Now, the telework requirement or the accommodation might be the best. It might be the gold Cadillac standard of what the individual is looking for, because it provides them greater flexibility. We all love the less pollution by driving our cars on the highway. We're able to do, home care. I like to do a load of laundry every once in a while. My wife is happy when I do that. But again, that telework gives us some of those options and opportunities to do those things, but that's not necessarily what the employer has to provide. Again, I think even with the pandemic, the employer just needs to look at what is going to make sure that we can perform the essential functions of the job. And again, what I would say as an employer, look at all the tools that you have in your toolkit. What are those things that you could provide? And always looking at, what does this job exist for? And what, as we say during our evaluation period, always, what is the result? Because I think that's what, as employers, we should always be looking at, what is the result that we're looking for based on the decision we make. I know I rambled, Haley, but I hope that was a good enough answer.
No, Tom, that's perfect, because I think a lot of times, employers are in the position where they feel like the interactive process is being driven by the employee. And if the employee comes forward with their preferred accommodation, that's the only tool, so to speak, at the employer's disposal. But I think you bring up an excellent point, and that is that this is an interactive process. And while the employee may express a preference for what that reasonable accommodation would be, it's ultimately the employer's decision and determination to determine what's reasonable based on the needs of the business and what will ultimately allow the employees to perform those essential functions, even if it's not the employee's expressed preferred accommodation. We're looking for what is the reasonable accommodation. So excellent point, and I appreciate you bringing that up. I think it also lines up really well with what's on the EEOC's website with respect to vaccination mandates. The EEOC on in its technical guidance actually spells out some of the reasonable accommodations that may be available for employees who are opposed to getting the COVID vaccine, whether it be for ADA reasons or because of a religious reason. And among the reasonable accommodations listed there are masks, social distancing, that is, putting the individual in their own office so that they don't have frequent interaction with customers or other employees, perhaps modifying shifts so that, that individual perhaps is working at a time when the office is less crowded, periodic tests, telework, but as Tom mentioned, that is listed kind of at the end of the list of potential accommodations. And then another one is reassignment. And to Glory's earlier point, I do not see anything on that list about placing employees on unpaid leave. And so, I think the notion is we need to try to work with employees to find a way for them to be able to perform the essential functions, not simply just exclude them from the workplace and put them on unpaid leave.
Yeah, and just adding to Haley, what she was talking about as far as examples of reasonable accommodation, the Job Accommodations Network. I don't know if you've heard of that. They are an amazing resource, even for us, when analyzing employment, ADA claims. The Job and Accommodations Network is, a service that's provided by the U.S. Department of Labor's ODEP, Office of Disability Employment Policy. So they actually, if you go on their website, they offer a lot of, guidance, technical assistance on various type of accommodations for certain disabilities. Employers can definitely use that as a guide. There's an amazing tool where they actually do have a landing page on, specific COVID related issues from telework, from vaccinations, and they, we work, in conjunction with them, on their website as well. They also list, our technical guidance on COVID and vaccinations and such. So, definitely use them as a resource as well.
Thank you, Glory, for that great reminder. And I need to encourage more of our clients to turn to that resource as well when, we're kind of debating what is the appropriate accommodation for a particular individual. So acknowledging that we anticipate that the number of EEOC charges related to, either ADA or religious exemption requests from a COVID vaccine mandate are likely to increase. Are you guys having any thoughts about whether or not you're going to, turn those charges into a more streamlined process, or do you anticipate that they're going to go through the regular charge process? And by the regular charge process, I'm referring to the employee submits their charge of discrimination and their summary of the discrimination, and then the employer would have an opportunity to respond through a position statement, and the employee, may have an opportunity to reply to that. Do you anticipate that those charges are going to be funneled into that, normal pipeline, or do you anticipate there being a more streamlined process?
I anticipate they're going to be funneled into that just a normal process. However, there are some cases that are probably going to wind up in our systemic unit. And the reason for that is because depending upon just the sheer volume, and if there are tons of charges filed against a particular employer, I know one situation looking at right now is it involves about over 8,000 people with one employer dealing with a COVID case. So of course, we're just trying to say, let's get that to our systemic investigator. Let's look at it narrowly focused, kind of, to try to work through it. Now, in that situation, for me, what's the most important thing is I know 8,000 charges will, if it was 8,000 charges, it would bog us down, really bog us down. But being that it's 8,000 against that one employer, I'll go ahead and tell you what some of our limitations are. One is that employer probably should have done an individualized assessment. We can't do that. I mean, not with 8,000 people, it's gonna, it would be almost impossible. So for me, what I'm going to be suggesting to my team is we need to have a sit down with that particular employer. Let's sit down and work out what are the real issues going on there, because we might be able to come to some kind of resolution that's amenable to all the parties, because it might be a real simple solution. Kind of, with some of the things that EEOC has outlined on its website that you mentioned just a minute ago, Haley, and that is, what kind of accommodations would work for that particular employer as well as work for those employees. And again, as I stated, one of the things that I'm really, I won't say fearful, but I'm anticipating, because again, we normally take in around 5,000 charges per year, that, we're probably going to have a 25% increase just with COVID charges. The one thing I would like to say is over the last 2 years, even with COVID, I think, Glory, your office has maintained less than 1% difference between each year of the charges. Some places it went down, but I think this year, being with mandates and things like that, it's actually going to increase. And there you go. And I was just looking at the chat. Someone wanted to know about the Job Accommodation Network.
And thank you, Jen, for sharing that resource with everyone. Let's shift gears again a little bit and let's kind of talk about some non-COVID issues, because I think we reach a point where we want to talk about things other than COVID, I guess. Talk to us a little bit about the non-COVID type charges that you guys are seeing, and what employers need to be thinking about and or doing that they're not doing. I know, Tom, when you've presented to us in the past, you've always provided some helpful insight into, here are a couple of nuggets you as employers need to take away from this, because these are the types of things that we're seeing over and over again at the EEOC. And here's, another way you can protect yourself.
Okay, I got to say one real quick, Gloria, and then I'm going to turn it over to you. It's just a commercial with the guy saying, is this really a Zoom meeting? We've got to figure a way, even with telework, to end sexual harassment. Sexual harassment complaints have actually gone up over the last 18 months. I'm just appalled that the harassment that occurs using the virtual world, via Zoom, Teams, or Facebook or other media. One of the things I think employers might want to think about is, if you are using a virtual platform, you need to put rules in as to how people are supposed to behave with those things. I know one of the things I was looking at in my strategic plan this year, and that is that when you show up to work and I call you on the team, turn your camera on, because you should be prepared to go to work. And if you're not ready, guess what? You should probably be on some type of leave. Meaning we've got to, since we're in the virtual world, guess what we've got to convince people to get back to? Being professional as they were in person. And perhaps that will help some of those harassment complaints go down. Now that I'm off my soapbox though, Haley, I'm gonna let Glory take that question.
Yeah, I think, Tom had said it, he's on point. We still see a lot of harassment complaints. I think, with race being the number 3 type of charge, we still see a lot of race harassment in addition to sex harassment cases. What I think employers should do is train their managers and supervisors. I think training is definitely key. because we find that a lot of supervisors don't know what to do. A lot of the charges we get, it seems that they're unaware of their, roles and responsibilities as a supervisor, that, once they see something, they have to, they have to take action. And it doesn't necessarily mean that, the employee has to say the golden words, right? It's basically, if, it's the known or should have known standard, right? That, if they're in there, if the supervisor is in that environment, then, that automatically sets the tone that they should take action. So I think, employers definitely should, just train their managers and supervisors. Not only train them often, but perhaps tailor it to, your workforce, right? Because it's not really, it's not cookie cutter. It just depends on, the work culture you have there and who your audience is. And, you sort of want them to be engaged, so that it's not kind of like, they're there to check off the compliance box or, meet any reporting requirements. But, you want to make sure that they get it, right? You want to make sure that, okay, if something happens, outside the training, then they remember and they know what to do. So I definitely think that, education and training is definitely the key for employers.
Very helpful, Gloria, and to, to make that distinction between not just completing training, but to make sure that it's tailored training. And Tom, I definitely like that suggestion of having Zoom or Microsoft Teams rules and policies that apply to your workforce, so that we all have the same ground rules and expectations about what is acceptable conduct when we're using those platforms for work purposes. One question that's come up, and I guess it's based really on an observation that we had when we started receiving notices of right to sue recently, and that is, it would appear that the EEOC has changed the content of its letter that it sends to a charging party when the EEOC is deciding to close its investigation. And so it issues what we commonly refer to as the notice of right to sue, which then gives the charging party the opportunity to file their federal lawsuit if they want to pursue the claim further. Has the EEOC changed its language or changed anything about its investigatory findings with respect to the charges that it doesn't choose to take action on?
I would say no. The appearance of the right to sue might look a little different, but in 34 days from now, it's even going to look more different than it does today, and that's because we're switching to a new platform. But for the most part, it's the exact same. And one of the things that we try to do before we issue the right to sue to a charging party is we do our best to conduct a predetermination interview with them, so that they're not just receiving it via the internet or in the mail without any kind of warning that, hey, this is what we found during our investigation.
Yeah, and I just echoing Tom, I think, that all sort of changed back in November of last year, when we sort of, the regulations were sort of amended to include digital service of the right to sue, because prior to that, we could only mail our notice of right to sue, but because of COVID, that sort of that sort of all changed thing, and that resulted in us, changing the way how we issue a notice of right to sue. And with that came along with a change in the language of that right to sue. So now you probably may see that instead of the box that says, the EEOC is unable to conclude that it's established a violation, now it just basically says that the EEOC is terminating an investigation, but this is not to ensure that respondent is in compliance. We are just basically stopping our investigation. And I think, what Tom had mentioned, in 34 days, we will actually we will actually transition into a new, case management system. The portal will still remain, it will still be the same, but as far as the forms, it probably will look a little different. Respondents and charging parties will still get access to the right to sue. It's going to have a little bit of a facelift, but that would still be the right to sue you received.
Yes, and I think we've been very happy with our new process of issuing the right to sues through our portal, doing it digitally. It's much faster, and we get almost instantaneous notice when the parties take a look at that right to sue, and it helps us making sure that we got the right to sue in the right hands.
You bring up a good point there, Tom. Since you are transitioning to this electronic system, does the EEOC have a way of determining if the charging party did in fact receive that electronic notice of right to sue, so that we are able to, defeat an argument down the road that, I never got that electronic notice if the employee is beyond the time in which they can file a lawsuit?
Right, we do, and the protocols that we try to put in place is that in our database we're able to see, to send it to, let's say, your email or the plaintiff's email. Then we're able to determine when it was opened, and if the parties don't open it, I think we have 14 days. If they don't open it, then we will actually mail a hard copy to the individual and make notation that we mailed it to them. However, we can always see on our side that the party's got it. And that's why one of the things in doing that predetermination interview with the charging party, we're also trying to confirm, hey, this is your email address. This is your mailing address, so that we're trying to say, we want to make sure we're sending it to the right person. We also, again, if the charging party is represented by counsel, we also want to make sure that we've got their correct email and mailing address also. Because again, our intent is we just want to get it to the parties as quick as possible. And again, we love it being in the digital format. That way they can always go to it and take a look at it.
Thank you for that explanation. Let's talk a little bit about the small handful of charges that are ultimately referred to your legal team for you to bring some sort of legal action against an employer. Can you talk us through how you make that determination as far as which cases get referred to legal, and then from there, is a lawsuit automatically fired, or do those charges sometimes come back to your local office for you to, take further action on? Just kind of explain to us how that process works.
Well, of course, I got to make you laugh this time, Haley, a little bit. See, we increased our litigation filings in the Charlotte district in fiscal year 2021 by 500%. We filed 5 lawsuits this year. So what Gloria and I do is anytime a charge comes in, we're looking at it from the moment it comes into the door, and we're trying to do a crosswalk of the investigation throughout. If it raises a red flag in our mind, especially if it's really egregious harassment or something dealing with the ADA, those kind of issues, we're gonna talk with our legal team. It doesn't mean that the case is going to actually ever be litigated, but we're going to, because always keeping in mind, we're the unbiased folk. We don't have a dog in the fight really, and the only time we really get a dog in the fight is if we issued a violation, conciliation fails, then we make a recommendation to our legal team. Hey, we think this is something you need to take a look at. Sometimes they do, sometimes they don't. If they decide to take a look at it, they might agree with us. And if they do agree, then it's sent over to Washington, to our commissioners, who take a vote whether to litigate or not litigate that case. And there are sometimes if they say, no, we're not going to litigate, they're kind enough to give me a phone call and tell me why. and that's good too. And I appreciate it. Because again, I think it's a wonderful process. The way we do that is because it's not a Glory or Tom looking at a case and saying, we think there's something here that should be litigated. It's that many eyes are looking at it. As they say, many hands make the work light. However, there's something else, on the flip side. There are sometimes cases that our legal team might think they want to look at that Gloria and I might say, we don't think that's a case that we think that should be litigated. We would prefer to see if we can resolve that case with the parties. Because again, for me, and I know Gloria is going to join with me on that, and that is the education of the employer, to me, is more important than the litigation. Because if you can educate and stop that behavior from ever happening again, that's already a win. Getting someone into court to prove that point, you can get a win that way, but you can also wind up in the loss column, and the organization thinks we were right all the time, even though their behavior was bad policy. But again, 500%.
It's quite the increase. One question we get from time to time, Tom and Glory, is about the notion of information sharing. And by that, I mean, does your agency share information with other federal or state agencies, whether that be, misclassification information? Let's say someone was misclassified as an independent, as an independent contractor when they should have more properly been classified as an employee. Or perhaps there's a tax issue that comes up during your investigation. Is there any information sharing between the EEOC and other state and federal agencies that occurs regularly?
The only federal agencies that we actually interface with, and I would say, and Glory can help me on this, is even our sharing is limited, and that is with the Department of Justice and with the Office of Federal Contracts and Compliance. And we do some conversations with the Department of Labor. However, the only time we're going to share is that we have to have a memorandum of understanding in place signed off by both agency heads, and it tells us exactly what we can and cannot share. My biggest interface is probably with the Department of Justice. And the reason for that is because if we investigate a charge and it's based on the ADA, Title VII, or GINA, and it fails conciliation and state and local government, we have to refer that case to the Department of Justice. So there may be many times, because I meet with them normally once a quarter. I think this year I'm going to go to once a month, just to say, hey, if there are any cases that I think that are headed that way, so that they have a heads up that, hey, this case may be referred over to you, because then we've got to also discuss, how do I get our digital file over to you? You know what I'm saying? Because it is limited, meaning they can't have total access to our database, nor do we have total access to theirs.
Thank you, Tom. That was extremely helpful. Well, unfortunately, we are just out of time for our discussion this afternoon, but I do want to thank both Glory and Tom again for joining us for this discussion. And I know we've extended an invitation to you to join us for our Q&A session later this afternoon. And so we'd be thrilled if you're able to join us. However, we understand if you've got to get back to the work that you do there at the EEOC. But again, on behalf of Warden Smith and all of our panelists today, thank you for joining us for this conversation.
Thank you so very much for having us. We always appreciate it, Haley, and good to see you all.
All right, and with that, I think we are headed into our next break before our last session. And so we will see everyone back at, let me check my schedule, 2:05.
Thanks, Haley. Thanks, Glory and Tom. You guys are wonderful to give us that time. That you're doing a tremendous service, for these employers, and I'm sure they greatly appreciate it.
Oh, well, thank you, Ken. It's so good to see you. And It's been a long time. It's hard to believe it's been almost 2 years since we've seen each other in person.
I know. And Glory, the last time I spoke to you, you were still in Hawaii.
Yes, indeed.
I hope you're finding Raleigh as pleasant as Honolulu.
Actually, yes, I do. I do love Raleigh. I'm actually still traveling back and forth, so I'm still in between coasts. I'm still in between coasts, but I definitely love Raleigh. It's amazing.
Well, good deal. I know, Gloria, you said you were coming back at 2:40 for the Q&A. We do have some questions that folks have asked, so we'll throw those your way when you get back. And Tom, if you're able to join us, we would love to see you again.
All right. Well, hey, well, thank you, sir. And hey, always a pleasure and good to see you.
Good to see you. All right.
All right. Bye-bye.
See you later.
Okay, it's 2:05 and we'll get rolling with our next session. As it has been indicated in the chat box, if you will get your phones out and text to the number 22333 and then in the message area, put WS webinar. And it doesn't have to be in all caps. It's not cap sensitive. So WS webinar all together as one word. And that's the message. And the phone number is 22333. And that will allow you to participate in the interactive portion that we're getting ready to start right now.
All right, well, I have the pleasure of asking you your first quiz question. Hopefully it's a softball. Okay. Under the expected ETS, or the Emergency Temporary Standard to be issued by OSHA, which of the following is most likely true regarding employers with 100+ employees that do not mandate COVID-19 vaccination? And this is for non-federal contractors. A, employers will have to provide on-site weekly COVID-19 testing for unvaccinated employees. B, employers will have to pay unvaccinated employees for time away from work to get weekly COVID-19 tests. C, employers will have to pay unvaccinated employees for time away from work to get weekly COVID-19 tests only if during their regular working hours. D, none of the above, meaning A, B, and C are all false. So which of the following is most likely true? A, B, C, or D? Well, it looks like I did trip some of you up by just one of the words that I used. For A, the key there is on-site weekly COVID-19 testing. We don't anticipate that anything in the ETS will require employers to provide it on-site, meaning that the requirement under President Biden's plan is that the employee will have to provide proof of a negative test. How we're going to get that proof is to be determined. One option may be for an employer to do on-site weekly testing, but it's not, at least our understanding is that it's not going to be required. The purpose is really that there has to be a negative test shown. So while A is I think an option for employers, it's not going to be required under the ETS that you provide the weekly testing on site. For B and C, they're just very slightly different answers, trying to trip you up. The first one is the more accurate. So B is the most accurate answer, meaning that employers will have to pay unvaccinated employees for time away from work to get weekly COVID-19 tests. C says only if during their regular working hours. And like I talked about in my very brief summary, the Department of Labor has come out with guidance not related to the ETS, but just generally saying that if you are requiring the employee to get a test outside of their working hours, you're going to have to pay them for it. Now, there may be ways that you can avoid that. And I think that's one question that we'll answer and we'll talk about in the Q&A. So the correct answer is B. So for the 22% of you who answered that, good job.
So our next question, I believe this one is mine, deals with, again, the expected ETS and the fact that, and here I can quote from the announcement of the White House saying that the rule will require that employers with more than 100 employees must provide paid time off for the time it takes to get vaccinated or to recover if they're under the weather post-vaccination. So here comes the question. May an employer with more than 100 employees issue and enforce a personnel policy that an employee must come back to work as soon as PTO has been exhausted? You see the 4 possible answers there. We'll wait for a few more. So far, we have unanimity regarding 1 possible answer. You can tell these answers are written by a lawyer because they're wordy. Guess I'll give it a few more seconds. It's fascinating to watch people's thoughts in real time. Give it just a few more. I thought that A might get a few answers. But the fact that it has not gotten a few answers suggests, oh, there, well, there was 1, at least for a moment. I can tell that we have a very astute audience because the majority of you have in fact gotten the correct answer, which, as you can see, is C. Because even though a policy may say, once your PTO is gone, you've got to get back to work because we have an economy to run here. We have a business to run. You need to come back and get in the saddle. The standards, whatever they say, will almost certainly, well, I will withdraw that. They will not contradict or supersede the ADA or the FMLA, which of course will and do require that if somebody, because of the vaccination, suffers from a disability or a serious health condition, the employee in that case may be required, may be entitled to a leave of absence as a result of the vaccination. So this just underscores, we hope, the fact that no matter what the standards may say, that for covered employers, which will be all employers with 100 or more than 100 employees, we'll still have to keep in mind the dictates of the ADA and the FMLA. I return to what I was saying before about the value of a policy addressing the use of PTO and what employees are to do if in fact their PTO has been exhausted. But as you can see from the answers, employers have to keep in mind and should have policies pertaining to the requirements of both the ADA and the FMLA.
All right, so the next question deals with proof of vaccination, like we discussed earlier. So which of the following is a true and advisable statement regarding how businesses can collect proof of an employee's COVID-19 vaccination? Is it A, require employees to submit proof of vaccination to Human Resources by providing a copy of their vaccination card to be kept in their personnel file? Is it require employees to wear badges and wristbands indicating their vaccination status? Or is it C, require employees to provide a written attestation of their vaccine status to Human Resources? Is it A and C only? Is it all of the above, or is it none of the above? We'll give you a minute to answer. All right. Things seem to be settling down. The answer is actually none of the above. A was a little tricky because I put kept in their personnel file, and it should be kept in a separate file so that medical information is not included with regular personnel records. The answer is not B because it certainly raises privacy concerns, and of course, if nothing else, it's not advisable because we think it causes tensions to possibly be elevated in the workplace, which would cause additional friction. C, incorrect, because requiring an employee to provide a written attestation of their vaccine status is not sufficient. And so for that reason, A and C wouldn't be correct, and all of the above would not be correct. The correct answer is none of the above.
So the next question is mine, and this one is a true or false question. So you'll type A for true or B for false, opposed to having the options like provided before. And the question is, employers are only required to compensate employees for the time it takes to receive the vaccine. True or false? So it looks like we're tapering off, and the longer we go, the more people are getting it right. That one is actually false. So at the very least, we know that the executive order is going to require time off for people to also recover from the side effects of receiving the vaccine. So we know that more than just the time that it takes to actually receive the injection will be covered. But as I mentioned earlier, there also are other times that are likely to be covered. So the time it takes for registration, the time it takes for travel, all of these things are times that you will have to compensate, and it will likely be, something that a limit of hours will be set out and helpful for some sort of guidance for each employer.
The next one is mine, but before I get into that, I'll piggyback on Justin's. In the medical or the healthcare ETS, it allows employers to set out a time or a reasonable amount of time that it's going to compensate people both for getting the vaccine and for potential recovery. And it typically, it's got to be a reasonable amount of time, but it allows folks to set out 4 hours to paid time to get the vaccine, and then essentially 16 hours to recover from the effects of the vaccine, 8 hours after each shot. And so it does allow that, and that's the healthcare ETS. We'll see if the ETS that applies to the 100 plus employee companies does the same thing, or if it leaves it more open-ended. All right, so this question assumes that we have a 120 person internal medicine practice that has 25% of its employees who are unvaccinated. They refuse to get the vaccine, and they've requested either medical or religious accommodations. So with that bit of background, which of the following are true, assuming it would be an undue hardship to the practice if it has to pay for 30 employees to get a negative test each week? So again, 25% of 120, if I did my math correctly, is 30. And so if it has to, this is a 100 plus person business, plus it's a medical business. So there's going to be a requirement that it has to do the mandatory vaccination. But as we've heard, even on a mandatory vaccination, you've got to at least consider medical and religious accommodations. So which ones of these, or what is the best answer? A very astute group did not fall for the trickery here. Certainly, number one says it cannot treat women less favorably than men. Well, that's generally a true statement. But then when we say, so it must approve or deny the request of women similarly to how it approves or denies the request of men. Actually, and this one, number 1 and 2, or A and B, fall into the same category because it's the same type of 2 is the same type of request. It cannot treat people of different races differently, so it must grant or deny accommodation requests similarly for people of color along the same percentages as it grants those requests for white people. Well, you would think generally you got to do that. However, what we know about ADA accommodations and religious accommodations is that you have to deal with each one of them on a case-by-case basis, and you got to look at the specific job that's at issue, what the person's condition or religious belief is, and whether or not there is an accommodation that can allow that person to do the essential functions of the job. So while we do have to treat people that fall in exactly the same categories or opposite categories the same if they're in protected categories, we still have to look at accommodation requests on a case-by-case basis, and can't let it be based on something because somebody's a man or a woman or of a certain race. We certainly, number 3, which did get some votes, talks about the fact that if we had granted these type of accommodations prior to President Biden's press conference, we're obligated to continue doing so. No, what's reasonable in one situation may not be a reasonable accommodation in another, and you're not ever obligated to do the same thing. Now, it could be that what you did previously can be used as evidence to show that it's still reasonable to do so, but it's not always going to be the case. And number 4, it must automatically grant a medical accommodation request for pregnant employees. Well, our recommendation would be that you give very serious consideration to accommodating pregnant employees, at least while they're pregnant. Certainly after childbirth, then they're no longer entitled to those protections. But you're not obligated. In fact, the CDC is recommending that pregnant women do get the vaccine. It's just that if you're giving accommodations to non-pregnant employees, a pregnant employee may have a potential pregnancy discrimination claim if they're not treated similarly. So just make sure that you're going through the interactive process because that is key.
Thank you, Ken. All right, moving on to another topic. As to which employees or employers are covered by President Biden's plan, which of the following is most likely true of the impending ETS? A is because vaccination relates to health, OSHA will follow the Affordable Care Act's FTE calculation for determining employer coverage. B, because OSHA is within the US DOL, OSHA will adopt the FLSA's definition for employee, which excludes properly classified independent contractors for determining which employees are subject to the ETS. C, because OSHA is charged with ensuring workplace safety, OSHA will utilize a head count calculation, including full-time, part-time, temporary, joint employees, for determining which employers are subject to the ETS. Because OSHA is charged with ensuring workplace safety, OSHA's ETS will not apply to remote employees. Because OSHA falls within the US DOL, OSHA will aggregate joint employers. F is C and D, but not E, and G is B and C, but not D. Looks like we're still fluctuating a little bit. I'll give it just a bit more time. Tried to make this one a little tricky. All right. Looks like we've stabilized. So you're right that A is not the answer. We do not anticipate OSHA will follow the Affordable Care Act's FTE calculation. So good job there. B is a possible good answer because not necessarily solely because it's within the Department of Labor, but we do anticipate a broad definition like that in the Fair Labor Standards Act for who qualifies as an employee covered under the ETS. C is also not a bad answer because we anticipate we will want to cover as many employers, and by using that, it would be the head count for calculating employees and then therefore the covered employers. So those two seem to be good answers. D, while appearing as if it makes logical sense, we do not anticipate, or excuse me, let me rephrase it. We anticipate OSHA's ETS will apply to remote employees because, as Xavier spoke about, the federal contractor ETS from OSHA does cover remote employees who are working on federal contracts. So while OSHA is charged with ensuring workplace safety, and there's we expect challenges on some of these issues, we do anticipate the ETS will try to cover remote employees. Again, that framework of covering as many folks as we can. E, so D is not a good answer, which many of you did not fall for that, so that's great. E, because OSHA falls within the Department of Labor, OSHA will aggregate joint employers. This one it's not a terrible answer, but more than likely it's too simplified. OSHA will aggregate, we expect, employer entities that operate as one employer. It's not solely aggregating joint employers always and treating them as one, but the employees of those joint employers might be counted towards the 100. So E is too simple. It doesn't dive into it enough. So if we go with that in mind, we know E is not the best answer. And we know that D is not a good answer. So that throws F out, which leaves us with G, which is the right answer, which many of you got. B and C, because we expect a broad definition for employee like that in the Fair Labor Standards Act. And we expect it to be a head count for determining which employers qualify but we do not anticipate that remote employees will be covered.
All right, so this question is mine. We have a true or false question here. Let's see who all was paying attention. Individuals that work remotely from their residence on a covered contract must obtain a COVID-19 vaccination to comply with the mandate. So in other words, here we have a situation where it is an employee who never enters the contractor's workplace. They work remotely from home, from their residence. True or false for this statement? All right, so just a little movement here. So the statement is true. And the reason this statement is true goes back to what we mentioned earlier, and also what Devin just spoke of as well. And that is that this mandate is designed to apply as broadly as possible. And so the key here is the language covered contract. If you have an individual who is a covered contractor employee, well, then that individual is going to have to obtain a COVID-19 vaccination. It does not matter whether or not the individual performs the work in the employer's or the contractor's physical workplace, or if the individual performs that work remotely from their home and never enters the employer's physical workplace. If they are working specifically on a covered contract, then they must obtain the COVID-19 vaccination. Now, you can also have a situation where you have individuals who work remotely and will never enter the physical workplace, who work in connection with a covered contract. So that may be support individuals, right? That may be human resources or billing or your legal folks. they will also need to obtain a COVID-19 vaccination. So this one will apply to both sets of employees, which I just described.
Okay, we're going to get rolling it's 2:30 now. And for the next 30 minutes, you have our undivided attention and can ask questions. We have a good number in the queue that we're going to start addressing. I think that the EEOC folks will be jumping back on in about 10 minutes. So we'll try to go ahead and knock out as many of the non-EEOC questions as we can, but please keep the questions coming. And the first question I'll go ahead and tackle in regard to the question states, it asks about litigation and how that may affect the ETS and the obligations. And here's what we can tell you. Certainly there have been lawsuits filed at different places all across the country. And we think back to 2016, and many of you who were in human resources at that time will remember when the Obama administration had proposed increase in the minimum amount that an exempt employee would have to make from a salary basis standpoint from $23,000 and change to $48,000 and change. And that was going into effect January 1, 2017. And in November of that year, the week before Thanksgiving, a federal judge in Texas issued an injunction, and that change never went into effect. And then the Trump administration took over in January, and they pretty much let that appeal die on the vine. And then they came out with a new set of regulations many months down the road, in fact, more than a year down the road. And that's when they moved the number up to 35,000 and change. But the bottom line is a federal court can step in and issue an injunction and stop this. The problem is that since OSHA hasn't issued these, the ETS for private employers, even though there are lawsuits that are filed, we're not sure these lawsuits are even ripe for determination yet, because the standard hasn't been issued. You need a standard to be issued so you can attack it, and there's nothing they can attack at this moment. And so some of those cases may get dismissed, although it takes time for cases to get through the system. And we believe that they're going to issue the ETS. There will be efforts to get it in front of a federal judge and to get an injunction. Whether or not it can be issued in time to stop the whole process is probably doubtful. There will be many people that get the shot anyway, but we'll just have to see as to whether or not it's going to be approved. And the fallacy of this whole concept, and this is also one of the other questions, this is not on its face a mandatory vaccination policy. Yes, certainly it is in regard to what Xavier talked about with the federal contractors and federal employees. And yes, in regard to the healthcare workers that are that may be affected. But in regard to just regular companies, it's not a mandatory vaccination policy. You could have 100 employee company and every single employee in the company could be unvaccinated. They would just have to test negatively every week. And so because of that, it's not on its face a mandatory policy. However, the cost of getting those weekly tests may be cost prohibitive, and it may force companies to mandate the vaccine on their own so they don't have to foot the bill for the weekly testing. And so we'll see how that plays out in court, but and it is definitely being litigated. But is it going to stop this ETS affecting you guys? We cannot say that it will. Another question, I'll tackle this one as well, is asking, when is this going into effect? And, you know, if each one of us on this screen secretly put in a date, you may have 8 or 9 different dates. My best guess when it came out in September was that we were going to probably have an effective date. Well, I thought we were going to get the standard by October 1, and we would have an effective date between November 1 and January 1. I'm going to still stick with the January 1, as we should have something in effect by then. Certainly, we've seen with the federal contractors, their date is December 8th. Isn't that correct, Xavier? And so we anticipate it'll be, you know, probably in that same ballpark. Anybody else want to tackle a proposed date? Okay. All right. Devin, why don't you take the next one, because I saw we had 2 different questions about a PEO and how that may account from a joint employer standpoint. So what are your thoughts about a PEO?
Yeah, the lawyer answer, it depends on the extent of which the PEO is providing service to the company, to the employer. In a situation where the PEO is serving in the capacity of payroll vendor, back office, HR support, various other things like that, and they don't actually have any control over the day-to-day operations of the employees who are working for the common law employer, that entity probably is not going to be considered a joint employer, looking at all of the different factors that the Department of Labor would look at. However, once the PEO is having a larger role and a larger connection, if they're staffing those employees to the workplace, they're supervising, they have their own policies that employees have to follow. In that situation, the employees would be considered employed jointly by the PEO and what I would call the common law employer, your company. And in that setting, there's a chance that the PEO and the employer could be aggregated together to cover everybody. There's an even better chance that the employee who is jointly employed by the PEO and your company would be considered one of your employees for determining whether you meet that 100 threshold. And you would be obligated to ensure that that employee is either fully vaccinated or subjecting to weekly testing. Staffing companies is one of the issues where it is with joint employment and PEOs, it's hard to say exactly if the ETS, which I hope it does, addresses that issue specifically as to whether companies, smaller companies that alone would not have 100 employees, but if they are somehow aggregated with a PEO that has employees, you know, they do the W-2s, they supervise in some capacity, they provide training. If they then are aggregated with those entities, whether that puts an obligation on your company. I hope that that is addressed specifically, but we have no idea to know for sure if it will be. The other thing to keep in mind is that if an individual is considered an employee of both the PEO and your company, you want to brush off your contract with the PEO to see, just like you may have done with the Affordable Care Act, to see who, even though you can't assign away a legal obligation, you can deal with it contractually. And so that employee may now be, because the PEO may have thousands of folks on its payroll across the country, that employee, if it's considered an employee of the PEO, it should be covered by the vaccine, either being fully vaccinated or subjecting to weekly testing on the PEO's dime. But that might be something you need to address in your contract with the PEO. Ken?
Okay, thank you, Devin. Emily, I have a couple of testing questions for you. Won't employers paying for testing time encourage employees not to get vaccinated and to take a test during work hours versus working?
That's a great question. And like Ken said earlier, I think the point I was trying to make is that we think that the paying for an employer choosing to do either or, meaning you can do weekly testing or get vaccinated, the employer may end up paying so much in either just the hard cost of the test and then the employee's time away to get the test, that they say, never mind, we're just going to mandate the vaccine because it's a better business decision for us. So that's why we think it's, having those stringent requirements placed on employers is going to put employers in a tough position as to the best business decision for them as to whether or not mandated vaccine. But I think that the person who asked this question is right. I mean, if the employee is given the option, then they may, and they did not want to get vaccinated and they have the option to do weekly testing, then I think that they will, continue to do that. But as Grant talked about with the importance of policies, if you do choose to do that, to have the weekly testing or the mandatory or vaccination, proof of vaccination, it will be important to have a policy that lays out how that works, meaning, are we going to have, at what times during the workday are you, and what day of the week are you going to go get tested, and trying to regulate that as much as you can to avoid employees going and getting tested on the weekends or outside of working hours, where you're going to be responsible for potentially paying overtime or paying additional wages.
Okay, let me, and another testing question. Do you think we will be able to standardize the amount of time we compensate staff for getting tested, for example, an hour per week?
That's a tough question, and the ETS may provide for clarity on that. But generally speaking, the Fair Labor Standards Act, and then whatever state your employee lives in, their wage and hour laws are going to govern whether or not it's compensable time or not. And if it takes a long time for them to get that weekly test, it's probably going to be compensable no matter what. But again, there's policies that you can put in place that can help regulate, whether that's coordinating with a particular vendor or having on-site testing. There's might be ways to help mitigate that problem. But my gut reaction is no. If it takes longer, you're going to have to compensate for that. But there is a possibility that the ETS will have some regulations around that issue.
Yeah, I expect that it will. Okay, Tom Colclaw and Glory. I'm going to throw out this first question for the EEOC, and it's my own question, okay? Because I get about 3 or 4 of these, if not a day, certainly in a week. We're a good number of employees are submitting religious accommodation requests in places where employers have mandated the vaccine. And they all seem, a lot of these seem to be templates or canned requests that have been pulled off the internet. They have similar Bible verses cited, and the person is, they've obviously done their homework, and they've never appeared to be a very religious person prior to this time. But all of a sudden they're resting on this religion that they have. And I know we're not supposed to challenge what's in somebody's heart, but can you give the employers out here some guidance on how do you deal with a religious accommodation request that, you think is a little bit suspect?
Yes, I'm going to give that to Glory.
Thanks, Tom.
No, that's a very good question. We'll do it together. You are correct. There are a lot of those situations going on. I was telling someone this morning about this one pastor in New York who has decided that if you give him a donation, he will give you a letter as an accommodation to not take the vaccine. So when I heard his story, I thought of the Temptations, their song, "Dealing in Dirt and Stealing in the Name of the Lord." So, but I think the tough thing for the employer is this: can you really question whether or not it's sincerely held religious belief? I think that puts you in a tough and precarious situation. So I would say that you're almost put in that position that you've got to determine whether or not can you accommodate and will it be an undue hardship for you. So my advice is strictly follow, our Title VII and the guidance for religion, de minimis cost, to see if you can actually do it. Glory?
I think adding to that, yeah, so like I said earlier, headquarters is well aware of, these type of religious accommodation requests, especially what Tom had mentioned about, I guess there is a minister that is offering religious accommodation letters in lieu of donation. So we are well aware of that, and our Office of Legal Counsel is reviewing all the issues that has come up with regards to vaccination, the mandates, and also religious exemption requests. So, like I said earlier, keep an eye out for that guidance, and that should be forthcoming. So,
Okay. All right. Thank you.
And can I add a complicating fact to gauge Glory's and Tom's thought on this? What if, we know we can't challenge whether it's sincerely held, but we can take into account inconsistent information, close in time to what an employee is doing to verify that it is the sincerely held belief, not completely made up. If an employee, and with social media these days, we know folks are going to social media to share their opinions on everything going on in the world. And if an employer sees the social media post where an employee is complaining about something and making folks aware of their opinion on vaccine mandates, and it's very closely tied to nothing at all religious. It's either political, or perhaps they even go so far as to say, I don't believe in this, but I'm going to try to get a religious accommodation, or I'm going to try to use the system, or something of that nature, where they clearly put out there that it's not just suspect, that they're saying, I don't believe in what I'm about to do, but I'm going to do it so that I can get around this. Does that change the analysis at all? I know the employer would still go through the interactive process, but is that information that the employer can actually use in making its decision as to not granting an accommodation request that they have, from the horse's mouth, so to speak, that it's not legitimate?
I wowould say yes, because then the decision is not based on religion, it's based on the other things that you're seeing. What are your thoughts, Glory?
Just adding to what you said, I think it was yesterday when we were talking about a case, or when we were training our new investigators, you're searching for the facts, right? If the facts is there, if the evidence is there to support that assertion, then you can definitely make that conclusion. Mm-hmm. Not to provide that accommodation because the facts, the evidence speaks for itself.
Mm-hmm.
Thank you.
Okay, the next question. Can an employer look up its EEOC history or determine charges that have been filed against it in the past?
I don't think our current database allows the employer to do that, but what the employer can do is they can make a request to us, such as one we dealt with yesterday. Hey, can you tell us the number, how many charges have been filed against company ABC? And yeah, we're able to do that pretty quickly. However, just keeping in mind that you could have some companies, depending upon the business that they're in, they could have hundreds of charges filed against them. It's not something that we're going to go back and look at. I know a couple of frequent filer charging parties. And we might know some of the same folk that I'm talking about. If you looked up their name as a charging party, you would see that they file hundreds of charges against employers, and that's why that's not something that we rely on.
Okay. this is one I actually dealt with that somebody's asked, an anonymous attendee is asking about. They requested an accommodation, not only from the vaccine, but also from the weekly test, or from getting a test. This is even before, I mean, the question is the weekly test. The one I dealt with a couple of weeks ago, the person was just against getting tested, as well as an accommodation to not getting vaccinated. What have you seen on requests for opting out of getting tested?
I think, I'm sorry, Glory, I'm gonna let you tackle that one, ma'am.
I actually haven't seen any that have come across my desk, but I actually have heard that, some folks actually do request an accommodation to not take, the weekly test because I guess there's some sort of, chemical or some sort of, I guess they use some sort of gene or DNA in the swab, right? That is against their religion. So that's really interesting. But I mean, I think what you have to do is you have to look at, the analysis of, whether or not it is a sincerely held religious belief, and if there are any type of accommodations that you could use in lieu of, getting the weekly test. Again, the Job Accommodations Network and also our guidance on vaccinations and I think Haley actually had mentioned it earlier about, are there other type of accommodations that you could provide? Could you social distance? Could you have the person wear a mask, or could you allow that person to work remotely? So again, I think the key is to just be flexible, right? Again, the whole, I guess, focus on reasonable accommodation and disability now under the ADAAA is, just engaging in that interactive process and providing that reasonable accommodation, right? In order for the employee to perform the essential functions of the job. So I think that's how you would approach it, regardless of, any topic, whether it be COVID related or not COVID related.
Yeah, the one thing I would also add with regards to our guidance, I was talking with someone this morning, believe it or not, and we were talking about, other than the standard COVID test, there's also, you can do a saliva test, but unfortunately the saliva test is not widely available. So that's something that the employer probably does not have, that they can use. However, our guidance at our, that we issued on May 28th clearly states that an employer can administer a COVID test as long as they can identify it as job related and consistent with business necessity. The other thing I've heard of someone saying, well, that if I take a test every week, it may cause nosebleeds. Well, again, that is the test that's available. The option is, the option is the vaccine, and maybe, we'll knock on wood, maybe that the pill is coming instead of the vaccine. But I think that, again, it's job related, consistent with business necessity, and the employer is always going to be able to use, is it that undue hardship defense of not having someone tested.
Okay. Here's the next question. Can you talk about if there's ever a circumstance in which unpaid leave is an appropriate last resort accommodation? I thought the answer to this was yes, but I am hearing potentially that's changed with recent law. And I think they're thinking about the case that you referred to earlier, Glory.
Indeed, yes. That United Airlines case is definitely, have had an impact on how we are analyzing the failure to accommodate, cases, especially in light of the vaccination and placing individuals on unpaid leave, not only for vaccination, but even for those who failed to use a mask. So again, I think it's sort of like a wait and see, and how we address it, especially, with headquarters and how they decide to, set the guidance out as well.
Okay. We actually have a question from an individual. scheduling an interview appointment online after the complaint is currently nearly impossible. What are other options for complainants to ensure they meet the time requirements?
Answer that.
Okay.
I get that.
She's
You
got
just
that
call
one.
us. Just call us.
Yeah.
I think, yeah, we have we have a hotline. We have a 1-866 number that folks can call. We also have, an urgent inquiry line. Hopefully that's available online, but I can share that with you all as far as, that hotline. Basically, when people call that specific urgent inquiry line, it puts them close to the nearest office within their jurisdiction. So, if you have a 919 number or a 984 number, that's going to automatically route to Raleigh. So we can call that. We also have our main line, so folks can also call our main line as well. We do have a dedicated email box that folks can also utilize, and it's raleigh.gov@eoc.gov. So we can definitely share that information with Jen after the event.
And we recognize that it's a challenge. One of the things that we noted in the month of August is that we tried to go through all of our, Gloria and her team, and I think our whole district did. We went through all of our inquiries that we had received since June 1 for a 90-day period. And I think we was almost 3,000 of those. That was in addition to probably another 4,000 in which people had called to schedule interviews. What we found was the issue is a lot of the inquiries, people had already scheduled the interviews. The tough thing is that when a person does it 2-3 times like that, we still have to make a phone call to determine is it truly a duplicate. So one of the things I would urge anyone to do is that if you already scheduled the appointment and you now have earlier availability, do as Gloria suggested, call us and just let us know. Because if you go back to the call center, it creates a new number, and we're kind of starting all over again all the time like that.
Okay. What is an objective reason for questioning a sincerely held religious belief?
Well, I did have a case once in which the person said that they needed to be off on Sundays, and through a little interview, more in-depth interviewing, we found out the reason for it was that the person just wanted to watch the NFL on Sundays. It had nothing to do with religion. So that's one of the things that I would definitely say, with every employer, find out exactly, if you need the accommodation, why? Some of the other things that I think I've seen, Gloria's probably seen it also, is you may find someone that says, I need the accommodation, but then you find out it's not really an accommodation, it's really a second job that they're doing at church, whether they're a musician or a pastor or something, it turned into a job, or something that they're actually volunteering for that may have nothing to do with religion. So just having that in-depth conversation, I think you learn a lot from the folk. And that might be a reason to question that sincerely held religious belief. And then you find out, as Devin stated, it's not based on religion, it's based on something else.
Here's one that's non-COVID related, Tom and Glory. Given this is the most popular EEOC case type, how does the EEOC evaluate the validity of a retaliation claim?
I would say carefully, I assume.
Carefully.
Yes, very carefully. Using the model of proof. And the model of proof is, did the person engage or participate in protected activity? Were they subjected to an adverse employment decision? Was the decision maker aware of the participation or their complaint? And is there a connection between the two? And that's a standard that we're going to use each and every time for retaliation.
Yeah, I think there's that but for standard for retaliation that you still have to look at, right? If not for, the charging party's protected activity, would they still have carried out that, that adverse action? So that's what we still look for, the but for standard. Were there's any other, performance issues prior to the complaint? What other situations happened that, occurred since the charging party made that complaint. We look at the timing. We also look at comparator information. So, I think those are what we look at when we analyze the retaliation charges.
Okay. We'll take one more EEOC question and we'll let somebody type that. And I'll just run through some of these that we can answer real quick. Where did the government come up with 100 or more employees? This number seems arbitrary. You're correct. But we suspect that because of that number, it will indicate that they are going to place certain standards on employers to pay for testing, and they wanted to make sure that the company had enough wherewithal to do so. That's presumably why they picked that number, although if their goal was to get everybody vaccinated, I'm not sure why they couldn't have gone much lower than 100 employees. But anyway, that's the number that they've set out, and we'll see more about that in the ETS. Next question, can an employer this is a medical employer, purchase tests and administer them on site to staff that are not fully vaccinated? Most likely you will be able to do that, but we're going to have to wait and see what the ETS says as to whether or not that's allowed. But we anticipate that particularly a medical employer would be able to do so. And it may be that regular employers are able to do so, or even do so over Zoom and verify that the person is taking a test. So we'll see what is allowed. What if the employer scheduled vaccine clinics on premises? Do we still need to pay for their time if they go offsite, or because we offer this, they don't have to pay for the offsite testing or vaccine? I think that's basically asking if the employer does set up a site, do they have to pay for the test? And it'll depend on what the ETS says. If the ETS doesn't give you that option, as being able as the employer to solely limit the employee's options, then most likely you'll have to pay for it in any event. But you certainly can set up a policy, and most likely the employees will need to comply with that. We've also been asked about smaller employers, those under 100. The ETS is not going to affect them, other than they potentially could be doing business with other companies that require vaccines of of employees to come on site. And that's a common thing that we've seen. And so you may get backdoored into, basically not being able to provide your own employees on somebody else's work site if your folks are not vaccinated, even though you as a smaller company do not have to have that obligation. Let me see if there's any other EEOC. Does anybody else see an EEOC question in there? Okay, well, we are at 3:04, and I want to respect everybody's time. There are still some questions in the queue, and it's great that we had this much participation. We really thank Tom and Glory for getting back on here with us. I know you guys are jammed up with everything that's being asked of you by Washington, and we really appreciate your time. You're all so generous, and I would hate to not mention the fact that in addition to the service you're providing our country right now, Tom is also was in the military, and we just thank you both for your service to our country, both at the EEOC and prior to that, Tom. And Gloria, you as well. And we thank all of the attendees. And Jen, you have some closing remarks.
I do. Thank you, Ken. And I'll echo Ken's comments. Thank you so much to Tom and Glory, and also to all of our speakers from Ward and Smith. We do appreciate all of our attendees spending their Wednesday afternoon with us. For those in attendance, tomorrow you'll be sent an email with information discussed today. We'll also make a recording of the webinar available. As a reminder, today's program was approved for 3 hours of HRCI, SHRM, and North Carolina CLE credit. All of the information to receive that accreditation will be included in the email as well. Once again, we appreciate you taking the time to join us. We hope you were able to take some of the information you learned today and apply it to your own business. Thank you again, and that concludes our 2021 Fall Employment Law Update.